Okay, Senator Kavanaugh, you are good to open on LB316. Welcome.
Thank you, Chairman Lathrop, and thank you, members of the Judiciary Committee. I feel like it was just yesterday that I was here last.
You did what?
I was here yesterday. It was a joke.
Oh, yes. No, you're good to be a regular.
My name is John Kavanaugh, JOHN-CAVANAUGH, and I represent the 9th Legislative District in Midtown Omaha. I'm here today to introduce LB316, which is to clarify the date in which 1 year limitation for filing a motion for post-conviction relief shall run. I brought this bill after consulting with Douglas County Public Defender Tom Riley, and I believe you should have a letter of support from Mr. Riley. LB316 simply clarifies that the 1 year limitation run from the date the Supreme Court of the United States denies a writ of certiorari or affirms a conviction appeal from the Nebraska Supreme Court. It simply clarifies provides clarity for the parties. As it currently stands, a defense attorney who has a client with a pending petition before the United States Supreme Court may have to advise the client to file a motion for post-conviction relief while that action is pending. Because one of the grounds relied upon is often ineffective assistance to counsel, that means a defense attorney may, in effect, end up advising their own client to allege that they are not doing an adequate job while pending cert for the United States Supreme Court. We've worked with the County Attorneys Association. I actually have a proposed amendment that basically this might not be the final version. We've gone back and forth many times. Essentially, there's a question about the notice requirement to the County Attorneys Association, or to the state side. And so just providing that, kind of showing where we're at. And if you take a look at Mr. Riley's letter, I think he can explain well the necessity for this and what problem this is trying to solve. But I appreciate your consideration, and if you have any questions, I'm here to answer them, and I believe Mr. Eichholt is also here, and if you have any other questions. But with that, I appreciate your consideration.
Senator Kavanaugh, did I hear this right? You're still working on it. It's a work in progress.
Well, that may be the final version. We kind of went through 3 iterations yesterday, and so the county attorneys just haven't come back and said that they're great, they're perfect with this one. We're about on the same place. It basically has to do just with the timing of and exactly how the notice is effectuated.
Okay.
So this may capture it, but I brought it to show you generally where we're at on that suggestion.
So just to be clear, you let us know when that's been resolved. Otherwise, I'm going to assume it's a hold for now.
That okay. Is fair.
Perfect. Any questions for Senator Kavanaugh? All right. Thank you, Senator. We'll take proponent testimony. Good afternoon.
Good afternoon, members of the committee. My name is Spike Eichholt, S-P-I-K-E. Last name is E-I-C-K-H-O-L-T, appearing on behalf of the Nebraska Criminal Defense Attorneys Association in support of LB316, and we want to thank Senator John Kavanaugh for introducing the bill. Senator John Kavanaugh explained what the bill does. It's really a pretty simple modification to the existing law with respect to post-conviction actions. The law now provides for a year window, if you will, for a person who is found guilty of a crime, they're in custody, and they've exhausted their direct appeal all the way either to the Court of Appeals or the Supreme Court. They have 1 year, if they want to file a request with the trial court to ask for basically an opportunity to argue that their trial attorney or their initial appellate attorney was ineffective for whatever reason. That year is pretty strict in statute, and the courts have made it even stricter for a variety of different reasons. There's a situation, though, what happens if you appeal all the way to the Nebraska Supreme Court, and you want to try to see if the U.S. Supreme Court can hear your argument, if you think you've got a federal argument, if you think you've got a constitutional claim or something like that. There's kind of an interplay between our state court appellate rules and the U.S. Supreme Court appellate rules that creates this kind of problem. You have 7 days after the Nebraska Supreme Court issues a decision to file what they call a motion to stay the mandate, or a request to the Supreme Court that they not send the case back down. You have 7 days to request that. One of the grounds you can give is that you are planning to file a petition for certiorari to the U.S. Supreme Court. However, you have, according to the U.S. Supreme Court rule, 90 days to request that following a state court final decision. So what happens sometimes is that your client won't say they want to go to the U.S. Supreme Court, or what is more likely, 30 days after, for instance, the Nebraska Supreme Court issues its opinion, you read something in another circuit that addresses exactly what your clients have just experienced, and you may want to go to the U.S. Supreme Court. You file a petition for certiorari. The Supreme Court then gives the lawyer who filed that petition basically a form where you are required to notify the state that you've done this, and the state can respond to that. They can file a brief. Basically, you're pleading for the U.S. Supreme Court to take your case. That can take several months. Meanwhile, if you have not filed a motion for stay, this 1 year clock is ticking at the state level. And then what you have is that you have this window is slowly shutting. You represent this client. They've got a year only to argue in the state district court that you were somehow ineffective in their initial case for whatever reason, and it could even relate to the same reason you're trying to get to the U.S. Supreme Court, and that's why there's this issue. The bill simply says that if somebody does go to the U.S. Supreme Court, that year starts once the Supreme Court either denies the cert or rules on whatever, if it takes the case and rules in whichever way. The prosecutors, I think, wanted just to have a provision where if you do file a petition for certiorari, they wanted us to file, the defense attorney to file notice in the original trial court at the district court level that we've done that, just so everyone is clear. As a practical matter, the Attorney General represents the state on appeal, but the prosecutor, the county attorney, is at the trial level, and that's why they may not realize it. I'll answer any questions.
Any questions? Just as a matter of background, a lot of individuals who have been convicted of serious crime, particularly death penalty kind of things, but very serious crimes, may want to allege that their lawyer didn't talk to all the witnesses, he slept through the trial, he didn't do something that was obvious, should have objected when they didn't. All of that's brought up in a post-conviction because they can't really complain about their lawyer when their lawyer's writing the direct appeal brief.
That's exactly
Get done with the direct appeals, that's when you can say, you know what, my lawyer did a lousy job and didn't live up to the standard of lawyers. Hard thing to prove, but this is just making sure the door is open for that. If someone appeals to the U.S. Supreme Court and the timeline currently in statute doesn't close the door on their post-conviction relief.
That's right. And this current scenario makes it even messier, because if you do go to the U.S. Supreme Court and that case sits there for 6 months and the U.S. Supreme Court says no, that guy races into court and says, look, that same lawyer had me sitting around in front of the Supreme Court docket for nothing, and that was one of the
Now I can't complain about it.
Right, that's exactly right. So this makes a clean break and has a new opportunity with a new lawyer if that person can make a claim. And it's a very uphill.
Are you involved in these conversations that Senator Kavanaugh's having with the county attorneys?
I am. Well,
do they have a problem with the fundamental idea of figuring out how to leave the door open for somebody that appeals?
I don't think so. I think they just wanted to make sure that the record was clear. And I think because what happens, and I can't speak for them, and unfortunately they're not here, it doesn't look like, but as I said, the Attorney General represents the state on appeal, and if it goes to the U.S. Supreme Court in some way. There's still a case number that's separate from the appellate number at the district court level. You file your petition for post-conviction at the original trial court level. And I think they just want to make sure, because one of the first things they do when somebody files one of these petitions is exactly right. They want to kick it on time because it's outside of the year limit. Because a lot of these guys, a lot of the defendants, almost all of them file it unrepresented. They file it their own. Sometimes a lawyer somewhere may help them sort of get started, but they file it themselves. If the judge sees they've got a meritorious claim, they can appoint an attorney to help them with it, or they can deny it outright. And one of the first things the state does at the district court level, the county attorney does, is say, you're 18 months past when the Supreme Court affirmed your conviction, judge moved to dismiss, it's out of time pursuant to whatever the statute number is.
Okay. Nobody's getting some big jump on somebody else. This is just taking care of sort of a hole in the process.
That's right.
Okay. That helped me. Any questions for Mr. Eichel? Seeing none, thanks for being here. Anyone else to testify in support of LB316? Seeing none, anyone here in opposition? See none. Anyone here in a neutral capacity? I see none. Senator Kavanaugh, do you wish to be heard? He's going to waive close. We have no letters, position letters, and we have one letter in support. This was actually written testimony dropped off this morning from Tom Riley, the Douglas County Public Defender. He's speaking on behalf of the Nebraska Criminal Defense Attorneys Association as a proponent. That will close our hearing on LB 316. Thanks, Senator Kavanaugh, and bring us to